In this lecture, we're going to turn our attention to criminal law. Let's suppose that lawmakers have defined a set of crimes in the criminal code. These definitions specify forbidden acts, relevant mental states, defenses that can be raised at trial, etc. Take the crime of theft, defined in the United Kingdom as follows. A person's guilty of theft if he dishonestly appropriates property belonging to another with the intention of permanently depriving the other of it. After lawmakers define this crime, the next part of their job is to design legal standards for those who will impose sentences on convicted thieves. Sentencing authorities are normally judges. Lawmakers must tell sentencing authorities which sentence or range of sentences they're legally authorized to impose on a convicted thief. Several philosophical questions arise. First, what moral constraints apply to lawmakers as they design sentencing schedules? Second, subject to those constraints, what reasons do lawmakers have to establish sentences for theft? In other words, what's the justifying aim of a sentencing scheme? Third, what sentence range should lawmakers establish for theft? One reason for establishing and using a sentencing scheme is incapacitation. Incarcerated thieves can't offend against anyone on the outside for the duration of their imprisonment. If incapacitation prevents a convict from harming someone, then that's a reason to incapacitate him. The fact that someone's committed a crime is, in many cases, a predictor of future criminal activity. Someone who steals a car for profit is likely to do so again. But evidence of criminality can take other forms. A psychotherapist may predict that her patient who's committed no crimes to date is likely to commit crimes in the future. Social scientists may predict that a member of certain social classes, family backgrounds, races, or religions is more likely to offend than others, even before a first offense. Lawmakers who see incapacitation as an important value might propose to preemptively and involuntarily incapacitate such probable offenders. This could involve making an exception to the act requirement of criminal law for specified classes of probable offenders. Alternatively, lawmakers could handle probable offenders outside the criminal justice system. Modern Western legal systems largely abstain from preemptive involuntary incapacitation. Most commentators strenuously object to it. The simplest objection is that any such policy will generate too many false positives. We just can't identify probable offenders with sufficient accuracy. In response, a defender of preemptive incarceration might observe that all criminal justice systems mistakenly incarcerate a certain number of innocents. How, she might ask, does her critic define too many false positives? But most writers believe that our technologies for identifying probable offenders are too imperfect to support even a limited policy of preemptive incarceration. Today's technological limitations do not, however, keep us from asking philosophical questions. What if in the future we're able to predict criminality with greater confidence than we can today? This is the subject of Steven Spielberg's science fiction film, Minority Report. Consider a future lawmaker who sees incapacitation as the only value relevant to sentencing. If she had sufficient confidence in the ability of experts to identify probable offenders, then she'd see no reason in principle not to institute a policy of preemptive incarceration. Nevertheless, many writers oppose preemptive incapacitation in principle, not just in practice. They deny that incapacitation is the only value relevant to sentencing. They accept as an independent moral constraint on sentencing what we'll call the legal guilt requirement, which says the state must not sentence anyone who's committed no crime. The legal guilt requirement plays a large role in punishment theory, especially in connection with another reason for sentencing: deterrence. Deterrence is a means of crime control, as is incapacitation. The idea is that lawmakers can deter prospective criminals by threatening to punish them. Of course, the threats are effective only if prospective criminals find them credible, and the threats are credible in practice only if actual offenders are actually punished, at least some of the time. So lawmakers undertake to punish actual offenders in order to deter prospective offenders. Deterrence raises several important questions. First, are prospective criminals actually deterred by threatened sanctions? Second, which sanctions, if any, are sufficiently effective to be justified as deterrence? Third, is deterrence a morally permissible reason to punish? The first question is empirical. A sentencing scheme only deters if the sentences are sufficiently unpleasant and prospective offenders are sufficiently rational, informed, and self-interested. One who actually attempts a crime was, by definition, not deterred by whatever sanctions the state threatened. Perhaps more severe sanctions would have deterred her, but crimes are attempted even when the known penalty is being tortured to death. No punishment scheme can eliminate crime. Punishment does, however, reduce crime. If the sentence for shoplifting were reduced to a 1-penny fine, then shoplifting would increase dramatically. The interesting empirical question is, What's the marginal deterrent effect of a unit of punishment for a particular crime in a particular society? If lawmakers increase the maximum sentence for shoplifting from 6 months to 1 year in prison, does less shoplifting result? How much less? The second and third questions have both empirical and moral components. A sanction is unjustified as a deterrent if it has bad effects that are too great relative to its deterrent effect. A minimum sentence of 5 years for public indecency might virtually eliminate this offense, but the public benefit would not justify the suffering of the occasional drunken offender languishing in prison. Writers often treat deterrence and incapacitation as the main social benefits of punishment, but there are others. Punishment can give pleasure to crime victims and the people who care about them. It can relieve their emotional distress. It can reduce vigilantism, reinforce social bonds, and confirm the legitimacy of the state. These societal benefits of punishment have something in common. They represent relatively external reasons for punishment. In other words, they have a relatively remote connection to the criminal herself and the nature of her crime, in contrast to relatively internal punishment values, which are more closely connected to the criminal and her crime. In the 18th and 19th centuries, philosophers of punishment such as Immanuel Kant and G.W.F. Hegel emphasized internal values. In the 19th century, British philosophers such as Jeremy Bentham and John Stuart Mill emphasized external values. Over the course of the 20th century, however, English-speaking philosophers began to reintroduce internal values. Many concluded that external reasons are not the only punishment values, that the state is morally constrained by internal values in its punishment policies. Some even concluded that it's morally impermissible to punish for external reasons. A basic argument for internal punishment values goes like this. If a state acts only on external reasons, then it will sometimes punish innocent people. Punishing innocent people is unjust. Therefore, it's unjust for states to act only on external reasons. The following thought experiment depicts a state that acts only on external reasons and punishes innocents as a result. A town has suffered a series of well-publicized burglaries by a clever burglar. The sheriff hasn't been able to apprehend the burglar, try as he might, and he has no hope of succeeding in the future. He just doesn't have the resources or the ability. Other criminals start to get the impression that law enforcement in the town is ineffective. As a result, they begin to commit more crimes, many of them violent. Victor is a friendless and jobless local hermit. All the evidence seems to point to Victor. The sheriff arrests Victor, then discovers evidence that proves Victor's innocence. The sheriff can easily destroy this exculpatory evidence and ensure that Victor will spend 3 years in prison. If the sheriff frames Victor, he reasonably predicts that the publicity will deter much violent crime. Framing Victor is bad for Victor, but it's good for citizens who would otherwise suffer from violent crime. Because the sheriff considers deterrence to be the only punishment value, he does so. Victor's conviction deters others, and fewer violent crimes are committed as a result. Similar scenarios can be constructed using any external reason for punishment, such as preventing vigilantism or giving people pleasure. The point is that, if the state considers only external reasons, then the innocent might, in theory, be punished. This violates the legal guilt requirement. Philosophers disagree about the proper lesson to draw from these hypothetical scenarios. A small minority of philosophers abandon the legal guilt requirement, but most take a different path. Some observe that the scenario is unrealistic, and insist that there could never really be conclusive external reasons to punish innocents. Their critics respond that the hypothetical needn't be realistic in order to discredit externalist theories of punishment. The fact that these theories could, in principle, conflict with the legal guilt requirement is enough to refute them, according to the critics. Any theorist of punishment must decide what she thinks about cases such as Victor's. I invite you to think about it for yourself.